A federal appeals court said an Indiana school district did not violate the rights of a former music teacher who refused to use transgender students' names and gender pronouns by forcing her to resign. Chicago, an Indiana school district said federal appeals court did not violate her rights by forcing her to resign after a former music teacher refused to use transgender students' names and gender pronouns in decision released Friday. 7. The decision of the U.S. Court of Appeals affirmed a previous decision by a federal judge in the case. According to court records, John Kluge was hired in 2014 as a music and orchestra teacher at Brownsburg High School, about 20 miles northwest of Indianapolis. In 2017, district officials began asking high school teachers to use nouns and pronouns listed in the school's official student database, where changes were permitted by letters from a student's parent and a doctor. Kluge told school principal Bret Daghe on the first day of classes for the 2017 school year that she has a religious objection to using transgender students' names and pronouns. District officials agreed that Kluge could address students by their last names and would not be responsible for distributing orchestral outfits. Other students, teachers, and counselors have also told authorities that the problem has plagued Kluge's class for many. In January, district told teachers that everyone should use the nouns and pronouns listed for students in database. In response to Kluge's questioning whether the rule would apply to him, authorities told him he could abide by the rule, resign or be fired. Kluge resigned and subsequently sued the school for religious discrimination. An Indiana federal judge ruled that Kluge's refusal to use transgender students' nouns and pronouns created unnecessary hardship for the district, which is responsible for educating all of its students. The appeals court agreed, writing that district officials tried to acknowledge Kluge's religious appeal but realized that allowing the music teacher to use their surname leads students feel disrespected, targeted and dehumanized and disrupted the learning environment. Brownsburg has shown as a matter of law that requested regulation places an undue burden on schools' educational mission by harming transgender students and negatively impacting learning environment for trans students, other students in Kluge's classrooms and school in general. Faculty was read. Rory Gray, an attorney for the conservative law group Alliance Defending Freedom, represents Kluge and said they are considering next steps. Congress passed Title VII prevent employers from forcing workers to give up their beliefs keep their jobs, Gray said in a statement. In this situation, Mr. Kluge did his best to welcome and treat all of his students with respect. The school district even allowed this arrangement before unlawfully punishing Mr. Kluge for his religious beliefs.